SJC-11842, Elmer Wing v. Commissioner of Probation.
If the probation department is withholding materials that are well within the ambit of the plain meaning of the rules that are out there, we have a problem with a fair trial. So it's not just Mr. Wing who suffers with regard to this, and the ultimate ramifications of a decision by this court may impact cases that have already passed. As can be seen from my brief, whether or not the probation department or the Commonwealth believe that first aggressor is appropriate in this case, it certainly is probably appropriate in other cases that have already passed. And if probation is only handed a record which is sanitized with a little S in the upper right-hand corner, and no one has caught the fact that there is a sealed record which may indicate violent acts in the past, you may have a problem, a systemic problem with how these rules are enforced. I mean, currently the rule defines what record means within its language. Within the court rule itself, the court rules say, and actually expanded the meaning from 26A, which just said prior convictions, the court's rules say the record is prior complaints, indictments, and dispositions, whereas 26A only indicates prior convictions. So when the courts created the rules, they actually expanded the definition, I believe, in order to help along with the concept of a fair trial and confrontation.
If you agree that you can't use it, right, under the statute?
Which one?
Under 100A?
Yes, I disagree with that proposition. I disagree with the proposition that 100A says that it can't be used in this context. First of all, if we take a look at 100A, its purposes are twofold. The first language says it shall not operate to disqualify a person from examination or appointment. It's a protection on employment.
It says that in part, but it goes on.
And then the second one says, nor shall such sealed records be admissible in evidence or used in any way in any court proceedings or hearings before any boards or commissions. And then it says, except in imposing sentence in subsequent criminal proceedings.
Yeah, well, this isn't, right, but that's not how you're going to use it.
No, and that's why I'm saying 100A applies to the person whose record has been sealed. It's an attempt by the legislature to keep the sealed record from becoming propensity evidence in a subsequent proceeding. It doesn't have anything to do with whether or not, under Rule 14, I have a right to the record.
Yeah, it has everything to do with it. It says it can't be used.
If it can't be used, then let me try the logic the other way. If it can't be used, and probation's position is, I can't ever get it, then it's mere surplusage, because if I can't get it, I can't ever use it.
That's right.
So, but it's mere surplusage then. You're interpreting the limitation on use as surplusage because you're saying, I can never get it. So what is the purpose of putting in the use provision? Use and seeing it. Accessibility and use of a document are two different things. For example, in most discovery, I've gotten many documents that are not usable or admissible, but they lead me to the discovery of admissible evidence. Just because someone can't use a document or cannot get it admitted is not the sine qua non of whether or not you produce it. You produce documents if they're responsive. Here, there is no exception. We'll try it this way. 100A through C was accepted by the legislature, accepted, EX, accepted by the legislature from the definition of criminal offender record information. They knew how to say the words, excluding criminal records sealed under Section 100A to C. They didn't say that in 26A. And the legislature was aware at the time of drafting 26A that there was a sealing statute.
Is there any limitation, put the rule aside, Rule
Yes.
14. Do you say that you have a constitutional right to whatever record any particular witness may have?
I have a constitutional right to those records provided to me under Rule 14 and 26A,
I said,
which is...
put the rule aside, just as a constitutional matter. Do you have that as a right of, do you have a right?
From what I've read of the Supreme Court law, that's not the case. I don't have a right to absolutely everything. But if there is a rule that defines what my due process is, which Rule 14 does, it's telling me that a fair trial will be, under Rule 14, I will get the record. Where is the interpretation necessary? That's an unambiguous word. In fact, it defines itself within the statute.
But the record is what's defined what it is that you get. So if it has been sealed, that's the record, a sealed record.
So record, no disrespect intended, record therefore doesn't necessarily mean record, it means a subset of record. That's what I get from that. And there's no, under Kacheri, the Kacheri court was interpreting the word now. And the Kacheri court basically said, if the word now is plain and unambiguous, we interpret it as its plain meaning says, now. Now under jurisdiction in 1934. Here we have the word record. 26A defines it as prior convictions. Rule 14, I didn't write the rule. Rule 14 defines it as complaints, indictments, and dispositions. All very clear words. It doesn't say except for or excluding those records that are sealed. Now, if I get them, that doesn't mean I get to use them in a court, but I get to see them. There is underlying data in those documents that may be helpful in formulating the defense.
You don't cite the Santos case.
I do not.
And we dealt with essentially the same question that's before us now, but in the juvenile context.
But that was an attempt to admit records at trial. If I recall correctly, that was an attempt to admit records at trial. We're in pretrial discovery. It's whether I get to see it. Whether I get to use it is a different question.
Why should you get to see something that you can't use?
The same reason I get to see things in regular discovery that I can't use, it's so that I can review it, and it may lead me to the discovery of other admissible evidence. There are going to be witnesses in the underlying files that I may want to speak to. The other thing is, I mean,
On the
I
record?
asked...
How is the record going to get you into underlying files with witnesses' names?
Well, typically, if I'm going to be able to get the record, I can then go to the court and see the files. And I can see who the witnesses are.
So sealed records are for misdemeanors 5 years after
Correct.
any sentence.
And they're 10
for
after.
felonies, 10.
Correct.
So you're suggesting that you can go back then and investigate what happened 10 years ago to see if there's anything there that possibly could relate to your current problem?
If I find it relevant, yes. I mean, I'm going to review the documents. I mean, in discovery, every day, as I've said before, every day I get documents that are not in admissible form and not in usable form.
But there's some analogy to the rape crisis records. You might be able, you have to show that you can use them, that you can be able to use them at trial. You don't just get to look at somebody's rape crisis records. Why isn't the same, doesn't the same principle apply here? You have to be able to show that you can use what might be in that record.
Because the relevance issue, I mean, that's almost edging up on Dwyer, if I recall the name of the case correctly.
Yeah.
But these are, if you take a look at the breakdown of the statute, under Rule 14 in the first paragraph A, it indicates that the prosecution decides what's relevant with regard to a handful of things. The legislature or the rule, the court rule with 26A has said that the record of prospective witnesses is relevant. I'm not disputing that here. I don't believe I have the right to dispute it. The legislature wrote it that way. By actually giving me the right to those records, they've deemed it relevant. They have not excluded 100A through C from it, even though in other places they do exclude records of 100A through C in other statutes defining criminal records or criminal offender record information. So they've done that before, but if I can back up for a second, if the complaining witness had not had her records sealed, would we be having this argument? Or would the prosecution have to turn over those records when they're not usable under the rules of evidence and they're not admissible under the rules of evidence either? So the question of admissibility seems to be a red herring. And the question of use seems to be a red herring, because I believe that if I came before this panel and I said, there is no sealed record here, I just want all of the record of prior convictions, complaints, indictments, and dispositions, I think everybody here would say that fits within the rule.
Now you mentioned some language to the effect that you're entitled to gain access because it might lead to other discoverable evidence. Is that language in the criminal rule 14?
No, it's not.
It's in the civil rules of discovery.
Well, it is my leap of faith. What it says is I can get the sealed record. It does not indicate that I can go to the courts and pull those files. As we all know, those files are then taken by the magistrates when sealed and put away in a different spot. That, to me, was going to be a fight for a different day, depending on where this fight takes me. But at the moment, the basic premise of my argument is I've got the word record, which is clearly defined in the court rules by whatever rulemaking body came to that conclusion, where they expanded what was in 26A to include complaints, indictments, and dispositions, and I don't see any ambiguity or conflict with the statute 100A through C, particularly where the legislature had the ability to exclude sealed records from the definition and has not done so to date with regard to Rule 14 or 26A. So I'm not sure that there's...
The rule is ours.
Yeah, excuse me?
The rule is ours. Rule 14 is ours.
Yes.
So it's not the legislature.
No, the rule is the court's rule, and they expanded the definition from what was just prior convictions that the legislature did. So apparently this court believed that prior convictions wasn't enough. In fact, the court expanded the rule to now become complaints, indictments, and dispositions. And complaints are very different than simply prior convictions. And it's talking about disposition. So this court apparently had a rather broad view of that to which the defendant should be entitled. But the rule itself, the 26A doesn't exclude sealed records, whereas in 167, Chapter 6, 167, when defining criminal offender record information, it does. So they clearly know how to exclude things when they want to.
Can you articulate what you understand to be your right of confrontation, your constitutional right of confrontation?
I'm sorry, could you repeat that?
Can you articulate what you would understand to be your constitutional right of confrontation with regard to the receipt and the use of these documents?
The right of confrontation, as stated by the U.S. Supreme Court, in my understanding, is a trial right, not a pretrial right. There is one case that I saw at the U.S. Supreme Court where it is a plurality decision, where half the justices sat there and said, how can it be a trial right if you don't get the underlying data to have effective cross-examination, when the majority sat there and said, you don't have a right to everything under the sun, you just have a right to effective cross-examination. That puts me in a difficult position.
And how does that play in? Put aside, I mean, we of course have our own right of confrontation.
Absolutely.
So let's assume, for the sake of argument, that we're not necessarily persuaded by your rule or statutory interpretation.
Yes.
But you would still have a right of confrontation to effective cross-examination. What would that realistically give you?
What that would realistically, I'm not sure if I understand the question, but I will try and answer it. What it will do is it will take away the data and say you can go in and cross-examine with whatever you can find other than what you're looking for, and I've been denied the ability to assemble data to create an effective cross-examination. Effective cross-examination is a matter of opinion.
But you haven't alleged bias in this case, that the witness whose record you're looking for is biased in favor of the Commonwealth. And you haven't alleged any of the theories under which you might have a constitutional right of confrontation.
What you're asking me to allege, or what you're asking me about, is whether or not I have shown you that the underlying documents are relevant, sort of like in Dwyer, which is a third-party issue, where you're trying to get documents from a third party, which doesn't apply here. It is somewhat odd to ask me to determine to give you the relevance of something, when my position is that the legislature has made it relevant by saying I can have it. The other thing, though, is that with regard to relevance, I've at least posited a couple of thoughts with regard to being able to get out-of-state rap sheets, depending on how extensive the in-state rap sheet is, to which my sisters have said, well, there is a signing of a document when you get the record sealed that says, I don't have any out-of-state convictions. Well, it seems to me it's my right to test the veracity of that statement by seeing. Putting that aside, the other issue that comes up is, despite how the case is characterized by the Commonwealth, I believe that there should be a right to bring a first aggressor claim here, and under adjutant, that would give me a more expansive view at the record. But we're not that far. I've just made a Rule 14 motion, and this is where it's brought me. I've had, I think, 1 pretrial or 2 pretrials, actually probably 3, most of them on this issue. And the relevance aspect of this, I submit to you, has already been determined by the legislature, and that to change the language of either the rule or the statute at this point is to do statutory interpretation, which is uncalled for.
Okay, thank you.
Thank you.
Good morning, Your Honors. May it please the Court. Sarah Joss for the Commissioner of Probation, and I would just like to note that we are splitting our time with the Commonwealth. Probation is taking 10 minutes, the Commonwealth is taking 5. This Court has not held, and Probation does not suggest, that a defendant may never obtain a sealed record. To Justice...
You do say that at the end here, in the brief filed, that he could seek to overcome the limitation of the sealing statute by showing a specific bias or motive to prevaricate.
And that's precisely what I believe Justice Spina was getting at, that the Court captured in Santos. In the final paragraph of Santos, this Court said that there is no uniform right of confrontation with a sealed record. Instead, if there can be a showing of specific bias, that it bears on specific bias or motive to lie, then there is a right of confrontation with the sealed record.
How is one to explore that without the record in hand?
I think it's going to vary by the situation. There may be circumstances where the complaining witness or any of the other witnesses and the defendant know each other. It's entirely possible that you might have, say, and imagination fails a little bit, but you could have one gang member testifying against another. They might know each other. They might know each other's history. There are a variety of ways in which a defendant could be aware of the prior history of the person with the sealed record. But I think the greater concern is that if we establish a process by which, as Mr. Wing suggests, that defendants simply get these sealed records, we have a great risk of chilling effect, that you have somebody who maybe has a 6-year-old misdemeanor conviction for possession of marijuana who's now the victim of a violent crime. I think the last thing anybody wants is to establish a process whereby that person doesn't want to report the crime or participate in the process.
Why is that person's right more important than the defendant's right?
It's not more important, Your Honor. It's a question of balancing. And I think this Court established that question in Santos.
But that was
following
in
the
a
concurrence in
trial,
Davis.
in a trial setting. That's not this.
Right, and I think that it isn't that it's more important. It's a question of balancing and how do we get to that. And to Chief Justice Gantz's point about how do we establish that process, I think there's a way to do this that comports both with the cases and with the carve-out that actually exists in Section 100A for when the legislature said a sealed record may be used. I think you could have a process whereby, as Mr. Wing notes, when probation produces the carry, which is the court activity record information, there's an S in the corner if a sealed record exists for that particular person.
If this were a more classic adjutant lineup and the defendant were charged with a personal crime against a person as opposed to a property crime, would your answer be different?
I don't know that it would, Your Honor, because then that person could still continue to argue and could make a showing of specific bias.
Well, why bias?
Well, if this person is the person who participated or was the aggressor, then they could go in. The person who is the defendant would know that, and therefore could make that argument that that person had a motive to please the Commonwealth because maybe they feared that they were facing charges or might be facing charges because they had in fact been the first aggressor. But I think on the adjutant point, while this court has not specifically addressed the issue of remoteness in the context of adjutant, the appeals court has done so on multiple occasions. So, a number of cases cited at pages 42 to 43 of probation's brief, and has held that when a conviction is remote, it no longer bears on or it demonstrates any sort of propensity for violent behavior, and that's precisely what this court noted in citing the Massing article in its 2014 decision in Pond, which is that the consensus recidivism research shows that after a period of time of law-abiding behavior, prior convictions simply no longer are predictive of future criminal behavior.
Well, now, in this case, I take it the defendant did get some probation record material. And are any of the offenses or any of the convictions usable for purposes of an adjutant issue?
That I don't know, Your Honor. But if they were, then they would be ones that were not sealed. And the sealing, as I believe Justice Cordy asked, is it's 5 years for a misdemeanor with no intervening convictions, 10 years for most felonies with no intervening convictions. Obviously, there are some exceptions to that. Sex offenses require 15 years. First-degree murder can't be sealed. And that if it's sealed, then that means that the person has had no intervening convictions between the time of the conviction and the time of the sealing request. And so it would therefore be too remote to be usable as adjutant evidence, which is precisely what this court was noting the legislature was trying to effect in Pond, is to diminish the collateral offenses of these old, stale convictions.
But you could have the same situation with somebody who had a 6-year-old conviction for marijuana, for example, but didn't have it sealed. There would be no reason not to produce that conviction,
and
even though it couldn't be used.
And I think that that's what the legislature is dealing with in 100A. They're saying that if it's sealed, if the person has taken the action to have it sealed, and there's no discretion if the person makes the application under either Section 100A or 100B. It's simply a matter of time and looking at the record, unlike 100C where it does require a weighing of those interests. The legislature said that as a matter of policy, we simply want to say that we are going to protect these people from collateral consequences when they've had this period of law-abiding behavior. If the person chooses not to seal the record, then their privacy interest in it simply is diminished because they haven't chosen to seal the record.
As to that
worried
point,
about-
on the policy issue, how is the legislative policy that underlies the 100, Section 100A, I guess it is, how is that undermined by what the defendant wants here? As I understand it, it's to help people who want to reform their lives and who want to engage in rehabilitation, get jobs. This has nothing to do with that. So how is this a problem for the policy underlying the statute?
Well, some of the explicit policies underlying the statute were housing and jobs and things like that. The more overarching purpose seems to be about protecting individuals who've had this lengthy period of law-abiding behavior from collateral consequences, which includes this chilling effect, that there would be
What is being protected by not disclosing a record in this situation? I don't get that.
Well, I think that there's the concern of the dissemination of a sealed record, and while Mr. Wing has counsel, not all defendants have counsel, and I think there's the risk with a self-represented litigant that they maybe wouldn't understand the import and
Well, don't you
protectiveness
have
of a sealed
protective
record.
orders with discovery? I mean, that happens all the time.
I
You
think
disclose things and you have an agreement about who can see it and what can be done with it.
And that actually was part of what I was going to suggest, sort of the overarching process here, that I think would read the rules and statutes harmoniously and afford both the protections intended by the sealing statutes and balance that with the defendant's confrontation rights, which is when probation produces a record under Rule 14, if there's an S indicated, the defendant can bring a motion suggesting that they believe that there's a reason that the sealed record would implicate specific bias or motive to lie, the court could then, as already contemplated in 100A for other circumstances, review the sealed record in camera to determine whether or not there are instances or entries in the sealed record that would go to what the defendant is arguing they do, and determine which, if any, of those entries should be produced to the parties. And I think that what that would give us is something along the lines of Dwyer, whereby when the defendant makes the motion, the defendant already having the name and address of this witness would have to provide notice to that witness that their sealed record is being sought. That person believes that they have, and this court has held that they have, or has at least implied that they have a privacy interest in that sealed record. And I think that that would give the court an opportunity to balance ensuring adequate confrontation rights as contemplated in Santos with the carve-outs that the legislature has already provided in Section 100A. And I think that that sort of balancing is going to both protect the confrontation rights and also not have not the same kind of chilling effect, and will also protect the privacy interests of the people that have had their records sealed. And I think that it also has the side benefit of ensuring that there is a uniform practice around these things.
But I take it that if such a motion were filed, it would have to be supported. A judge wouldn't have to engage in this process unless the judge concluded that there was something sufficiently alleged that might make this record.
Right, so that there would be some sort of showing in the motion that the defendant had reason to believe that the existence of the sealed record, or something that they maybe had learned through collateral sources about what was in the sealed record, bore on specific bias or motive to lie, which is precisely what this court says in the last paragraph of Santos.
Is your point, in terms of the argument that Mr. Bond makes about, the statute uses the word record, the court rule uses the word record, that we should interpret record in both those contexts as meaning available record, that is, unsealed record?
I think that's correct, Your Honor.
Is for some constitutional reason or whatever that you would get underneath that ceiling.
I think that's correct, Your Honor. And I think what that does is it gives effect to the protections written into the sealing statutes. And to Mr. Bond's earlier point of, access being different than use, as a number of the questions seem to get at, once the sealed record is seen, it is being used, whether it's actually used in court, which would be the admissibility portion of 100A, or used to develop a line of questioning or investigation.
What does the statute say about use? Is it any use of sealed records in any court proceedings?
It is, Your Honor. And
in any court proceedings. So
it is.
That suggests something a little bit narrower than what you're talking about, any use. Do you just look at it and that's a use?
It actually says, nor shall such sealed record be admissible in evidence or used in any way in any court proceedings
In
or
any
hearings.
court proceeding, though.
Used in any way in any court proceedings or hearings.
Is there any legislative history on this?
I know the court discussed some of the legislative history in Pond.
No, in terms of that language.
I don't believe that there is. That predates the 2010 Corey reform. But I'm not aware of what the
The language
legislature-
predates the Corey reform.
The language is, the timing, I believe, does not. That what the court did, or what the legislature did in the 2010 Corey reforms is match up the timing of 233 Section 21, which is the general impeachment by prior conviction statute, with the timing for sealings in Section 100A. And so, unless there are further questions, we would
I got one more
certainly-
question. We have this chicken and egg issue with regard to, you say, well, the defendant can present a motion, and Mr. Bond says, how can I argue persuasively that I'm entitled to without knowing what it is? Would probation have any obligation to, probation would have knowledge of what the sealed record is. It's not generally their job, but would probation have any obligation in such a motion to give notice to somebody of the possible pertinence of that record?
It's frequent that probation isn't involved or aware of the motions until such point as in this circumstance, there was a motion to compel a sealed record.
But probation would be aware, but because you would say they have to put the S whenever they disclose it.
And when the carry is produced, it actually just automatically has that S if a
So
sealed
that's
record
generated
exists.
electronically.
It is. And those are produced by probation staff in the courthouse once the court order comes from the judge to the probation department. And so what we suggest in urging this court to adopt this multi-step process is that because the defendant will in fact know the identity and address of the witness for whom they're seeking a sealed record, they could provide notice. And in fact, we argued that in the brief that Mr. Wing could have done so and simply didn't. If, however, the address is impounded, then certainly the DA would have that address and could provide notice.
All right, thank you.
Thank you, Your Honors.
Good morning, Ms. Lee.
Good morning. Mary Lee, Assistant District Attorney for the Commonwealth from the Plymouth District. The Commonwealth would first note that the defendant has asked for dismissal in this case, and I would like to start my remarks by saying dismissal of the criminal complaint in this case would be entirely inappropriate. The Probation Department has done nothing wrong. The statute 100A requires probation to report to private individuals that no record exists. And so there's no wrongdoing and certainly no prejudice to the defendant that would warrant a dismissal in this case. And moving on, I'd like to turn my attention, unless there are current questions for me, to Justice Lang's question about why is the witness's right more important. And it is because the legislature has determined that information in a sealed record is confidential by statute, making it akin to other statutory privileges like this court dealt with in Dwyer and prior to that Bishop in Fuller. The legislature here has promised that individual, because they have met the requirements of the statute with completing their sentence, having that waiting period with no intervening crimes, that they then are eligible for sealing. It becomes sealed, and then that witness can go around and tell everybody, I don't have a criminal record. Now, what will happen if this court just makes a sealed record part of 26A and this court's rule in Rule 14 is that defendants will then get automatic, that is what the defendant is asking for here, automatic access to sealed records in every case.
Suppose it was not automatic access, but access that access was automatic, but on the condition of that it not be disclosed.
Well, I would suggest that that would be a better proposition in terms of what the defendant is asking for. But what I'm suggesting to the court is that you don't need to make a new rule in this case. You, as probation has pointed out in footnote 22 of their brief, you have a rule for statutorily protected records, and it's in Dwyer. You use Rule 17, you make your showing why you need it, which would be consistent with this court's decision in Santos, that the defendant has the burden to show why he needs it, and then the judge in Dwyer hands the records over only to counsel. I would suggest in this case, the statute, as written by the legislature, requires an in-camera review before admitting an exception to opening up those records. And I would suggest that would make perfect sense in this case. So let's take this scenario. We have the defendant saying, I want it under adjutant. This was a Maldi case, but I was in fear, is his claim in his brief. And so that request goes to the judge. The judge can then look in camera at those sealed records. And I would suggest if they are acquittals or dismissals, the defendant is not going to be able to meet his burden of showing either bias or to show that they are relevant to adjutant. And then the judge could look at those charges in the case and say, are these threats of force? I mean, a possession of marijuana, which is now not even illegal, I think a judge would be well warranted in saying there's nothing in those records that's going to help you in your case. And further, if it's not
Not criminal.
it's now civil, yes. It's now civil and not criminal for possession of marijuana, but other matters like an OUI or a prostitution charge or other kinds of drug charges, how would those be relevant to adjutant? And then the judge could make that in-camera ruling and then proceed to the Dwyer protective order. Counsel can look at it, you come back to me before you report it. And that would be consistent with, you don't have to create a new rule, you're applying it to statutorily confidential records, and the defendant has a burden to make under Santos. So that doesn't require this court to make any changes in the law, nor should you. Because the other answer to Justice Lang's question about why is the witness's right more important is answered in this case in Pawn. The legislature has a very important interest in the ban the box provision, that we let people make their mistakes, pay for them, go by the waiting period, and then move on with their lives and report, as the probation department will report, that no record exists. And if we just hand over those records, we're going to end up with defendants using them in court. Discovery equals use. And further, the defendant's use of those records, even with counsel, in this court, in these proceedings in this case, required the Commonwealth to bring a motion to impound, but for a period of time, that information of the allegation of a sealed record with a named individual, without any reason for putting in his brief, was public record in this court. It was used in this court in violation of the statute, and if they will do it at the SJC, they will do it in the district courts, and it will have the chilling effect that my sister described. I'm asking this court to do what you did in Pawn and approve of the legislature's use in this case. The defendant does not have an out-of-hand constitutional right to these records, as I have cited in my brief. There's a particular provision that goes through all the case law. This would be an appropriate situation to find the defendant has not met his burden under Santos.
Thank you.
Thank you, counsel.
Thank you.